can keep on joining. In the meantime, we'll do a quick recap of what we studied in the previous class. So in the previous class, we began our discussion from the topic single transferable vote, right? Then we saw largely the conditions of service for the president, including the topic fund, CFI, PAI, and the contingency fund. We also saw then the powers and functions. Yes, of course, Article 61, impeachment process of the president, which can be initiated by giving prior notice by at least 1/4 members of the House. Beyond that, we saw Article 74, especially Clause 1 was very important, which made the advice of Council of Ministers binding on the president. And then executive parts, all of them, including the concept of pleasure of the president. Moving on, we also saw the other executive functions. Then we saw some financial parts. We saw judicial part, of course, the military part or the defense part, because the president is the supreme commander of the armed forces in the country. And then, of course, we ended our discussion on a brief discussion on Article 72, which is what? Clemency. So we covered all these topics yesterday. I had asked you to read chapter 2 of political theory. I hope you have read the book, right? And the chapter. And political theory must be done. You must have also studied the monthly magazine for 1 hour. And also revisions must have taken place at least twice or thrice. So expecting these things to have happened. Great. So let's begin today's discussion. Of course, today is the World Yoga Day or Yoga Day, right? So practice your half an hour of yoga today. See, when it comes to the discussion on current affairs, till I teach, that is till the next month, I think 21st of July is the last date of the class. Whatever has happened as far as polity is concerned, all changes, including some pending cases, I'll be covering in the class. But of course, for future references, we'll have to follow the monthly magazines that are given. Okay, that's it. So how to tackle political theory? It's just an NCERT book. So if you're in class 11th or 12th, I can understand a predicament that its book could be difficult. But if you're in a graduation, reading a class 11th book should not be that difficult. It's a very easy book, a simple read. Don't complicate it. Just read it at least thrice, right? That should suffice. Don't worry. Okay. So let's begin our discussion for the day. And for those who have joined, say, today or have skipped on the first 2 classes or have missed it by any chance, feel free to watch the live videos. You'll get information on what books to study, what current affair material to follow, what is this book, Political Theory, all in the very first class that we discussed the first 1 hour. Okay. Now, let's begin our discussion. We know the deal. First 5-10 minutes goes on into some practice questions. So, get ready, 45 seconds. And the first question for today is this. Please mark your preference accordingly. Okay. Okay, a lot of you got this correct. Great. The president is elected by an electoral college consisting of elected members of parliament, of course, and the state legislative assemblies. So one is correct, no problem. Nominated members of both the houses of the parliament and the state councils also take part in the elections. No, nominated members, they do not take part in the elections. So two is wrong. And the voting is done by open ballot. No, the voting is through a secret ballot. That is why we said that the party instructions are not applicable here. It's all secret voting. There is no need to show your vote to any other person. You are free to cast your vote in respect to any person you want. That is called open ballot. What is secret ballot? When nobody can see your vote, it's called secret ballot. What is cross voting? Cross voting means if a Congress MP votes in favor of a BJP candidate or BJP supported candidate, that's called cross voting. If a BJP person votes in the favor of Congress supported candidate, cross voting. So to reduce cross voting is allowed actually. There is no whip during the election of the president. So the voting is through a secret ballot discussed under the chapter president. Okay. So 3 is wrong. A, only one statement is correct is the right answer. Okay. Moving on to the next question. Solve this again. I think some of you forgot to see the incorrect part here. Maybe that could be a reason for marking the wrong answer. Right? Please mention how many of you did not see the word incorrect. The president can be removed from his or her office only on the grounds of violation is correct. One is correct. The impeachment charges against the president can be initiated by either house is also correct. Both statements are correct. Only the elected members of parliament can participate in the impeachment process. No, both of them, both elected and nominated, take part in the impeachment process. 3 is wrong. How many statements given above are incorrect? Only one statement is incorrect. So a gentle reminder that questions need to be read properly. Okay. So only one is correct. MLAs don't take part in the impeachment process because the president is the part of the parliament at the central executive level. So his removal should be confined only to the what? To the central level. That is why. Okay. And this is which article? Article 61. All you have to do is revise. So if you don't revise, you would not know what the hell is all this happening. But if you have revised, you'd know under Article 61, the president can be removed on the grounds of what? Violation of the Constitution. Okay. Moving on to question number 3. Okay, a lot of you got this correct. Some of you marked this wrong also. Under Article 61, the president cannot be removed for misbehavior. Of course, that is correct. The president cannot be removed for misbehavior. This is absolutely correct. The president can only be removed on one ground. And what is that ground? The ground is violation of the constitution. There is no other ground to remove the president. Okay. Then the president can voluntarily submit his resignation to the chief justice. No, this is actually wrong. He submits to the vice president of India. So one is right, but two is wrong. And the president can hold his office beyond 5 years. I think we discussed this statement yesterday also, that yes, the president can hold office beyond 5 years. If there's any delay in the elections or some other reason, he can continue beyond the term of 5 years. So two statements are correct, B being the right answer. Moving on, question number 4. Oh, just 38% got this correct. With reference to Schedule 2, Schedule 2 contains what? Schedule 2 contains salaries and emoluments of certain categories of people, right? Which group's salary is not mentioned there? Of course, the salary of CEC is not mentioned there. Chairman of UPSC is not mentioned there. Judges of subordinate court, salary is not mentioned. Salary is mentioned for the president, for the governor, for the presiding officers, which means Speaker of Lok Sabha, salary of Supreme Court and High Court judges, and salary of CAG. These people's salaries are mentioned under Schedule 2. So, not mentioned 2, 3, and 4. D is the right answer. Okay. Last question for today. I'll give you a minute since it has 4 statements. Okay. A lot of you mark D as the answer. I'm not sure why. Money bills require prior recommendation from president. Of course, is correct. No problem. President can issue orders to establish an interstate council. Is correct. The president can declare an area as a scheduled area. Is correct. As per the constitution, the CGI acts as the president. Really? Not as per constitution. This is as per the President Discharge of Functions Act 1969. As per this law, not as per constitution, right? So this, I had actually explained this statement also, that in the constitution, it's only mentioned that VP becomes the acting president. But in 1969, because of circumstances, we had to make a law to provide for this. So 4 is incorrect. Hence, 1, 2, and 3. Only 3 statements are correct, which is the right answer. Clear on this? That's it. We are done with the questions for the day. Let me just show you the leaderboard. As of now, though we'll show this towards the end also, Shalini, Surya, Bhavan, Janvi, Shruti, Shanmukh, Kambapati, Rai Verma, Lavanya, Jyoti Sharma and KK. What does KK stand for, Mr. KK? Then we have some people who have gotten 4 correct. A lot of you must have gotten 4 correct. The leaderboard only shows top 20. So, okay, let's move on now. Starting with the first topic, clemency powers, Article 72. There are 5 different types of clemency powers. I hope we remember that. And the clemency powers refer to what? Pardoning powers of the president. The power of president to pardon some convicts. Okay, so moving on. Now understanding what are these clemency powers, what are the various types of clemency powers. We have 5 types of clemency powers, very easy to understand. Let's follow. First up is pardon. Pardon is the best form of clemency. If you apply for pardon, it would mean that your sentence, your punishment, conviction, everything has been removed. You are absolved of all the guilt. All the guilt has been removed. In short, you are free to go. You're a free bird. Okay, this is called pardon. The highest level of what we call as a clemency power is pardoning. Okay. Next is commutation. Now, commutation refers to changing the nature, the character of the punishment. We change the nature of punishment. For example, if somebody has been given a death sentence, then we change the death sentence into, say, a life imprisonment. That would be called what? Commutation, meaning punishment is not removed. There is some kind of punishment, just a different punishment. That is what is called commutation. Clear? By the way, life imprisonment means till the natural end of your life. It does not mean for 14 years or something. Now, remission. What is remission? Remission means to reduce the period of punishment. Reduce the period without changing the nature of punishment. For example, maybe you are given life imprisonment here, or punishment of, say, 20 years of jail. It can be reduced to 14 years. That's possible. This is called remission. Pardon, all punishments removed. Commutation, nature of punishment is changed. Remission, the time period of punishment is reduced. Then respite. Now, what is respite? If you observe, whenever any politician gets arrested, suddenly the politician's BP increases, right? Sugar level increases. Suddenly the politician has thyroid, all such problems. Otherwise, he was enjoying life. So what happens is when you are arrested, and especially if you're convicted and you are facing some problem, you are taken to the hospital. Now, hospitals are 100 times better places than jails. So in the jail also, let's say you're given some jail duty, okay, to cook food, clean the washrooms there, clean the premises. But if you are ill, sick, have injured yourself, then for a few days, months, etc., you can be given a lesser, more lenient punishment, awarding a lesser sentence on account of special fact. This is only for temporary period, not permanently. Let us say you are given the punishment jail duty to also clean the what? You are given the jail duty to clean the washrooms every day. So, and you are injured now, or you have become sick, pneumonia. So for 1 month, you'll be said, don't worry, just sit in the jail, eat free food, enjoy, don't clean the washrooms. So this could be, special fact could be reasons like health. It could be because of injury, etc. Okay, that is called respite. Finally, reprieve. Now, what exactly is the meaning of reprieve? What is reprieve? Reprieve, think of it. Think of commutation. What is commutation? Your life imprisonment or your death sentence is modified into a life imprisonment. But see, who will issue this order? The president. So let's say the Supreme Court gives a judgment that today is 21st. on the 7th of June, or 7th of July, 2023, we will be giving you death sentence. Death sentence. Okay, death sentence. Now, today is 21st. You file a request for what? Request for commutation. You send a letter to the President of India for commutation. But understand that in the jail, you send a letter through your lawyer. This letter will reach the President and should reach him before this date. Yes or no? But if you are using the Great Indian Postal Services, there is a possibility that the letter reaches the President on 8th of July because of how quick our services are. Right? No, but on a serious note, it may also be possible that you send a letter and the President gets the letter in time, but he is not in the country. Or anyway, to look into any case, why should you be shown mercy? What is such a special reason, etc.? Some time is required for the authorities to go through your case, find out what was wrong, what was a challenge, what was an issue with your case, what's the story, what are the mitigating circumstances, why did you commit such a crime, why did Supreme Court give such judgment. The President has to go through all these things. It'll take some time, maybe a month or so, right? So because the President needs time, now in the meantime, if the President is still deciding, the date for punishment has come, you will be executed only. Yes or no? So what we do is initially file for a reprieve. Reprieve means there'll be a stay order put on the execution of the sentence, meaning you will not be killed till the President decides on your commutation. So temporary stay on execution of sentence pending the completion of what? Clemency proceedings. So there will be a temporary stay. For how long? Till the President decides. This temporary stay depends on time taken by the President to decide. It can be 1 day, it can be 10 days, it can be 100 days, it can be 10 years, right? So this is what is reprieve, where the President will take some time and in the meantime, you will not be executed. So largely it is meant only for death sentences, okay? Because in a jail sentence, you are already in the jail. What's the problem? So execution of sentence is executed, it is performed. Clear? So this is with respect to all the 5 types of clemency powers that the Indian President has. Now, very simple point that you should also know, and why would there be a need to show mercy like this? Tell me, why would we want to show mercy? After all, this person has committed a crime, and what's the need to show mercy? Mercy can be shown because of various reasons. Okay, one reason is also the importance of the right to life. Importance of Article 21. What else? See, there is also a possibility of judiciary going wrong, right? So, correcting possible judicial errors. Also, sometimes judgments are very harsh. Correcting very harsh punishments. Some judges can be prone to giving a very harsh punishment. So, if the judicial verdict is too harsh, unduly harsh, then maybe the President can show mercy. Okay. Then sometimes, new evidences or facts come to light. New facts come to light. If you have seen this movie called The Shawshank Redemption, you will appreciate this fact that things can go wrong, judgments can be wrong. Sometimes you might not have committed the crime only. Somebody else committed the crime, but still you got punished by the court. It's all possible, right? Then there's also an aspect of remorse. Possibility of remorse. The feeling of guilt shown by the convict. He wants to improve. Okay. He wants to improve. He wants to change. We have to give scope for rehabilitation. We have to give scope for reform. These can be various reasons as to why the president might use clemency powers. If he feels that it is required. Clear? So this is there. Apart from it, sometimes laws are very harsh. Some old laws, that's also an element. Some laws are obsolete, meaning very old, and they give a very strict punishment. For example, sedition as a law, or Section 377 used to be, still there. Homosexuality was a crime till 2017-18. So all these things. Now, coming to some very important elements of clemency power. Supreme Court over the years has given various elements, various aspects to clemency power. First up, these are, what is apex court? Apex court means Supreme Court. Supreme Court is the topmost court of the country, hence called the apex court. Number one, president's decision is subject to judicial review. Clemency power is open to judicial review. This has been said by Supreme Court way back in 1981 in the Maru Ram case. Okay. So whenever the clemency is shown, the judiciary can check it. Why was it shown? I remember S.H. Kapadia, former Chief Justice of India, made a very good statement. He said that clemency is not a private or personal act of grace and mercy. It should be based on logical grounds. You cannot simply show mercy on grounds like political loyalty, religion, caste, etc. Because when you show mercy, it has a very important effect on the society at large. So you have to keep in mind the family of victim also. You have to keep in mind the society as a whole. You have to keep in mind the precedent, the example it may set for future. So based on these things, also mercy should be shown, right? There is a victim also involved. Yes, we understand the right given to the individual who was wrong, the convict. Victim's family is also there. So taking all these things in mind, we should ensure that mercy is used in very specific cases with proper and genuine reasons. Then number two, one very important element. Don't ever feel that this clemency power, Article 72, is some kind of checking of judgments. No. The president is not questioning Supreme Court judgment. The president is not overturning a Supreme Court order. You have accepted the court's order. All you are saying is that, President, please show mercy. Yes, I am wrong. I'm sorry. I want to improve. Please give me a chance. Are you clear? So it is not that the president is saying, Supreme Court, you are wrong. We are removing the judgment and then I am forgiving you, the person. No. You are showing mercy, accepting the Supreme Court's order. That is why clemency powers are independent of judiciary. They do not depend on judiciary. They are not some kind of challenge. So they do not overturn judgments. It is separate. It is outside the judicial system. Apart from it, sometimes Bollywood, the Hindi cinema industry, tends to create a very wrong image of laws. One such example was a movie, I believe, Jigar, 1990s. It was a remake of some Van Damme movie, Blood Sport, I believe. Anyway, that's not important. In this movie Jigar, what had happened was, towards the end, this actor Ajay Devgan and Karishma Kapoor, they wanted to seek mercy from the governor. So in the movie, they show that Ajay Devgan and Karishma Kapoor, both of them take a pink rose in their hand and walk towards the governor's office. This is not how mercy is sought. Let me clarify. You don't have to take a pink rose to president or send a yellow rose to the president. You file a request through your lawyer. It goes to the president's office. That's it. Task is over. You cannot say, sir, please give me a chance. I'm very good at crying. I was earlier also in Indian Idol. I know how to make emotional and I can cry and all. I can convince you. I can roll down on the floor there. Please hear me out. So, of course, it is not to be the case that you insist on oral hearing, that please hear me out. No, 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 not required. You sit in the jail, you wait, I'll decide on my own. Clear? This is what Supreme Court said in the Kehar Singh case, that the petitioner cannot insist that please, I want the president to personally listen to me. And lastly, just to clarify, even the clemency power is not the power of president. Sorry to keep you in the dark so far. Some of you may have thought, oh, real power of president. This is under Article 74, not the real power of president. Clemency has to be exercised on the advice of Council of Ministers. This was the Shamsher Singh case of 1974. So even clemency power is not the real power of the Indian president. Before you start thinking otherwise, that oh, real power. So it is not the real power of the president. Clear? So these are some of the important points that the Supreme Court has shown, made mentioned in order to properly use the clemency. Now, you know what? This power is of the government, Home Ministry, basically. So Home Ministry shows clemency. I'll ask you a simple question. Let us say today somebody has been given death sentence to be executed on, say, 10th of July. 10th of July is the date of execution, date of killing the person. And that person files for a clemency petition, requests for clemency. Please tell me, how much time do you think is sufficient for the court to decide on clemency? Tell me, what do you think? The president to decide. In how much time can the president decide on clemency? What do you think? 1 month, 14 days, 1 week, 30 days, 1 month, 10 days, 2 months, 30 days. Okay. 6 months, 15 days. Fair enough, fair enough. So basically, the president can decide in around 2-3 months. That's what most of you think, that it should not take more than 6 months. Fair enough. Do you think it should take 10 years to decide? Tell me, yes or no? 10 years? Of course not. 10 years is too much. It used to happen. It used to happen that somebody has requested for mercy and it is pending for 11 years. The person in jail every day sitting and waiting. What can I do? What to do right now? Today, every day at 3 p.m., the post office guy comes in the jail. The person runs to the gate and says, my clemency petition accepted. The post officer says, sorry. Postman says, sorry. No letter has come. Imagine the amount of mental trauma that the person undergoes. See, we understand and all that, yes, you are a convict, you have committed a crime and all. But is it right to take 10 years to decide? 10 years? Home Ministry could not find a time to decide on that. But if you don't want, reject it. You know, this happened that around 2013, 2014, a petition was filed in the Supreme Court. There were around 15 such prisoners, 15 prisoners, whose clemency petition was pending. 15 prisoners whose clemency petition was pending for, you know, how many days? 1.5 years to 11 years in some cases. 11 years. Mangalal Barela in Jabalpur Central Jail, or Shivu Jadeswamy in Belgaum Central Jail. So many people. 11 years. Finally, this matter went to Supreme Court in front of 3 judges. Supreme Court gave some statements and gave some directions that need to be followed. That case was the Shatrughan Chauhan case 2014. Shatrughan Chauhan case. Now, the point here is Supreme Court said that, see, if you don't decide quickly and take 5-10 years, then you don't commute death sentence, we will do it. Supreme Court said that undue delay, if there is too much of delay, and insanity, if the person goes insane, becomes insane, pagal, right? If he becomes insane, mentally of unsound mind, then Supreme Court said, we will give a commutation. We won't wait for you. It has happened. For example, just a few years back in this case of Renuka Shinde, and the Seema Gavit case in Maharashtra, these ladies had been convicted of kidnapping 13 people and the death of at least 5 children. They were given death sentence, but their mercy plea was pending for more than 7 years. 7 years, 8 months it was pending. So finally, the Bombay High Court said, if you are not deciding, if it is taking you 7 years to decide, 8 years to decide, we are showing mercy. Go. We are showing clemency. And your death sentence is now removed. You will now be in life imprisonment. Okay. This was the case. Then one more thing. Supreme Court said, please don't keep people under death sentence on any kind of solitary death row, meaning death sentence. So people who are undergoing a death sentence, they should not be kept in solitary confinement. What is solitary confinement? It means keeping the person separately, alone, because this can result in mental trauma. Solitary confinement. Can you understand? Remember the pandemic time? We were in our home, within the confines of our house, with our loved ones, with internet and all the nonsense, and still we were feeling lonely, not feeling okay, getting depressed. Imagine somebody is undergoing death sentence. What must be going on in their mind? So all these things, they can cause, mental trauma. So in this case also, undue delay. Imagine the situation. The person is in jail for 10 long years, waiting in the jail for your mercy petition. And finally, after 10 years, you say, rejected, go and kill him. Then you are putting double punishment. Yes or no? Double punishment. Firstly, you are putting the person in jail for 10, 12 years and then also killing the person. So all these things happen. That's why we say that all these delays, it has a dehumanizing effect. You are not treating human beings as humans. Dehumanizing effect. Then Supreme Court also said that there should be regular mental health evaluation of death row convicts, because we cannot mentally unsound criminals cannot be killed, right? Okay. Then one more thing, that minimum 14 days gap from last remedy to date of execution. What is this? So I believe most of you would remember this case that happened in JNU of Afzal Guru, where some of the kids, they were kids, we should call them kids only because they were college students, at least most of them, apart from the ones who were politically motivated, most were college kids only. So they were protesting with respect to Afzal Guru's hanging. Now, let's not get into detail of what was the problem they had. But one point that was being raised was actually appropriate. See, Afzal Guru was a terrorist. Whether you like it or not, he had confessed on camera also, evidences found against him, as simple as that. So whether you become emotional and all, we don't know. But the fact remains that the court had held him to be guilty and given death sentence is fully accepted. Now, when he had filed for mercy petition, his mercy petition was rejected and he was killed immediately. Now, his family members came to know of the killing through media. That is something not nice. I mean, yes, you may have committed a wrong, but what happens is, when it comes to committing any kind of wrong and a mistake, you are somebody who is behaving like an animal. The society cannot. The laws cannot. We have to show respect to your family. So ideally, there should be some time gap given to you from the last remedy, that is your clemency request. That's the last remedy that you have, clemency request, to the date of execution of punishment. Between this gap, there should be at least 14 days. If today your mercy petition is rejected and the president says, go and kill him, then at least 14 days time should be given before we kill you, so that you meet your family, make amends with everything, come to terms with the reality of you being dead and all, right? All these things. So there should be at least 14 days time given to you before you are killed. Clear? And lastly, one simple question: when we kill people in the country, right? When we kill people in the country, then what happens? How are people killed in the country by the state? By hanging by the neck till you die. That's the killing. So when it comes to this hanging, how do you think a person dies when he is hanged? Through choking. The person does not die through choking, because when you choke somebody, asphyxiation, you are cutting the oxygen supply to brain. It may take lot of time, right? So when you hang somebody, the bone breaks and it punctures the vertebral column at the back of your neck, and you die instantly. Instant death, right? Instant death is what is there. That is why we have to ensure that we conduct a post-mortem, and all the convicts who are killed, they should have died instantly. Because what? Dignity when you die also. Your right to life means dignity, and you should die with dignity. That is what we want to ensure. So this was Supreme Court's judgment in 2014. So after this case only, now you will find that these guidelines are followed. Okay. So this is with respect to clemency powers. Are we clear on this? Now, as of now, there is no time limit set by the court also. Court says that if delay happens, undue delay for no reason. How much delay? 1 year, 2 years, 10 years, we don't know. It is still subjective. Still subjective. But still, the point is that there should be some kind of time frame. Understand it, that a time frame is very, very important. Otherwise, it will amount to torture. Torture. So, what can be a possible suggestion here? Suggestion. There should be some kind of ideal time frame fixed. 6 months should be fixed. And now, beyond that, if there's any further delay, extra delay or additional delay, the government should be asked to explain reasons why there is a delay. What is happening? What is taking so long? I think we should justify it, right? And the Home Ministry has to become serious about all these things, right? Second point, MHA get more serious on these petitions. What is MHA? For those who will ask me, sir, what is this MHA after 13 years? I am telling you right now only. MHA means Ministry of Home Affairs, MHA. Now, the government can also say that, sir, ma'am, the citizens of our country, we are the Home Ministry. We have a lot of things to do in life. We have to care about the citizens also. We don't have time like this. We can't decide in 6 months. We want more time. Simple. You are saying that you want more time because you are busy. No problem. Take all the time on this planet available to you. Do one thing. Why don't you give this power to some other body only? If you are so busy and you have no time, let somebody else decide on this. So, alternatively, what more can be suggested is, let me write here. create a separate body. We can call it pardon board. This body can be given the task of dealing with such kind of issues. This pardon board can comprise of, retired judges of Supreme Court, retired judges of High Court, maybe some social activists, NGOs, human rights activists, etc. Right? So this can also be done. And this pardon board can decide and make recommendations to the president. But in short, we have to minimize the time. This cannot be allowed. 10, 15 years with respect to deciding all these things is too much. Even the courts have been silent on what exactly is the time. Look at the Seema Gavit case also. This happened only after 7 years, 10 months. Right? That's too long a time. So this is again a suggestion. So these are the opinions given by the Supreme Court and the orders given by Supreme Court in the Shatrughan Chauhan case 2014. I hope the point is clear. We are done with the what? Clemency part. So just to for somebody, I think somebody is posting that what is this last point? So see, the last point basically means that if you are killed by the government, that is how are people killed? Follow me. People are killed by hanging. You take a rope, tie it around the neck of the person and kill the person by hanging. But when you hang somebody, the person does not die because of choking. That's a misconception amongst people. Basically, when you fall down, you fall so fast with the weight and the sudden break in the fall that the bone breaks at your back, puncturing in your neck, puncturing the vertebral column at the back of your neck, and you die immediately. Instant death. No pain. Painless death. We can't torture you. Right? So painless death. So we have to always, when we kill somebody, we have not we, the state, okay, in the jail. When the state kills somebody, then they will have to also look into how the person died. The person should have died always with puncture of the back of the neck, vertebral column puncture, because it results in immediate death. Okay. So that is it. I hope Utkarsh and others post-mortem point is now clear. Okay. Tajinder, life imprisonment, and for others also, life imprisonment means till the natural end of your life. And if the person did not die because of vertebral puncture, then basically you can only die through choking. Maybe the policeman involved can be punished for some suspension of some days because they did not perform their task properly. That can happen. Okay. And the Ministry of Home Affairs is the body which actually looks into these punishments, right? See, as I said, Nag Lakshmi. Somebody did ask me, what is MHA? I knew very well this would come. MHA means Ministry of Home Affairs. Right? Suddenly we wake up from slumber sleeping and oh, what topic? MHA. What is MHA? Type a question immediately. Right? I know morning classes, but coffee, tea, right? A bit of jogging, running, all these things can be done. Now, when you say, somebody says, Gauri, should you remember this case? Yes, this case is very important. Landmark case. Must remember it. There is no big deal. Just 5-6 points. That's it. Okay? Don't worry. So this recommendation of clemency comes from the Home Ministry. Home Ministry is the authority which makes recommendation. Home Ministry will tell the Council of Ministers. Council of Ministers will recommend to the President. That's how it is done. Okay, that's it. We are done with the discussion on the clemency parts. Now, coming to, since we are already discussing clemency parts, right? Let me just extend the discussion further to a very sensitive topic, capital punishment. What is capital punishment? Death sentence. Capital punishment means death sentence. Death sentence. So, tell me, should we have death sentence? Yes or no? Tell me. When I say death sentence, yes or no, no means in no case whatsoever. We should not give death sentence at all, or yes means yes. Don't write yes in rare cases. No, no, don't play safe here. Simple answer, yes or no. Okay, a lot of you are writing yes. Tell me advantages. Why should we give death sentence? Tell me, come on. Patel, torture them until, come on, Patel, let's be realistic. Will you torture them? If we ask you, here is a person who has killed somebody, come on, you torture him now. Will you do it personally? Who will torture the person? Avoid crime again. Justice to victim, set example. No one can repeat them. Justice to victim, threaten the criminal, set a benchmark, set example. People will be scared, sense of fear, satisfaction. People will face fear, justification, no advantage, maintain law and order. Okay. So a lot of you are saying the same thing. You are largely saying that this should be done so that to set an example, so that crime is not repeated. Clear? This is point number 1. Okay. Okay. What else? People also said that it provides a sense of satisfaction to the victim. You know, a sense of expectation of justice, that I was wronged or my family was wronged. There should be that. Reducing the number of criminals. More place in jails. Seriously. How many death sentences have we given so far? Since 1951, 755. That's it. India can afford to keep 755 people in jail, right? That is not a real concern. If you look at the number of accused in jail, they are more than 3 lakh people. If they are given bail, jail population will become empty. One more reason I heard was, yes, somebody is a repeat offender. Repeat offender, meaning non-reformable. Non-reformable, somebody who cannot improve. This person, if let out, will commit the crime again, right? Repeat offenders, they are possibly a threat to the society. Fair enough. Advantages. Now, tell me some of the issues. Issues with giving capital punishment. And the first thing, to all those people who said that it sets an example, it creates a situation where no one else commits the same kind of crime. So to them, I want to ask a simple question. In the Nirbhaya case, we gave death punishment to all the possible convicts who we could give. One was a juvenile minor, the other person committed suicide. The other people, we gave them death sentence. Yes or no? Did we give them death sentence? Yes. When we gave them death sentence, then suddenly all the rape stopped happening in the country. Yes or no? Tell me. Okay. If your answer to this question is no, then how have things changed? Where is the setting of an example? Is it happening really? Or you're saying, yes, rapes have stopped happening. Really? Then we have to look into the news items on a daily basis. Nothing has changed. Okay? You cannot simply say this is the biggest misconception. Harsh punishments. Set an example. No proof. There is no proof of this, that give a harsh punishment and they it sets an example. It's the biggest myth across the globe. It has never been proven anywhere. And let me just clarify. There are two types of countries on the planet. Before you become angry and all, that how is my point being challenged through logic? Become emotional only. Understand this. There are two types of countries. One group is called retentionists. There are 55 such countries. And other group is called abolitionist. These are countries. 142 countries, right? In terms of retentionists and abolitionists, retentionists are those countries which have retained death sentence. Abolitionists are those countries which do not have death sentence. In fact, more countries on the planet don't have death sentence. Now, somebody has mentioned that in Saudi they give harsh punishment and crime rate is too low. Crime rate is too low. First, you have no data to suggest it. But anyway, let's assume a crime rate is too low. It's still there, right? And the same can be said for Norway also, Sweden also, Finland also. There also crime rate is very low with no death sentence. Then where is the evidence? The evidence means that it should be standard across the country, globe. So there is no such evidence to correlate that death sentence means what? Low crime rate. In some countries with no death sentence, there is low crime rate. So relationship is not there. Anyway, retentionists, and in India, we have given so far 755 death sentences, 1950 to 2021. That's it. So this is point number one. Harsh punishments are also possible, right? Otherwise, some other points can be death sentences irreversible. It can't be reversed now. Then it amounts to cruel punishment. It also violates the right to life. That also gets violated. Then most countries, they have abolished it, right? Apart from this, a very, very important point. A very important element here is that you must have seen that in a lot of these foreign countries, if an Indian criminal gets caught there in other countries, what happens? These countries don't send the criminal to India. Why? Because in India we give death sentence. Those countries do not. So, lot of countries do not sign mutual legal assistance treaties with India to help us. Why? Because they will not deport or extradite a person to India because we give death sentences. Apart from this, there is always a possibility of reform. Who are we to deny reform? Who are we to say somebody can never can never improve? And I'll give you a simple example. A lot of the people here would, I'm sure, hold a very strong opinion with respect to rapes. Okay. Let me tell you frankly, most rapes or any sexual assault of such kind is committed by people who are known to the victim. It's either some school friend, college friend, some relative, neighbor. In most cases, not just in India, world over. Have we not seen these horrific stories of women coming out saying that in my childhood I was molested, I was raped, I was harassed by my uncle, some cousin, etc. Right? So all these things happen, and the point is when we give an opportunity of reform to such a person who belongs to our family, scope for reform there, right? Then how are we denying this reform to people who are, say, poor or let's say otherwise? So reform can only happen in a middle class or an upper middle class or high class family, right? Because let me tell you, in how many cases have you seen death sentence being given to a rich person? You can maybe count it on fingers. How many examples are there of death sentence being given to a rich person? Capital punishment comes to only those people who don't have capital. That's the reality, right? But we are quiet on this. Somehow the poor can make all the mistakes, the rich cannot, middle class families cannot, because the mistakes we make are covered, right? Hidden, put under the bed, that, oh, please don't talk about it. So that also needs to be understood, right? There is always scope for reform. So there is always a possibility of reform, which is an issue with capital punishment. When you give death sentence, you're removing the possibility of reform. And lastly, uh, the most important point that was mentioned in the South African constitution was that if you look at the trials or murder trial, the outcome of a murder trial depends on so many things. The manner of investigation, how has the prosecution presented the case, what is the financial capacity of the accused. If I'm a rich person, I can hire a better lawyer, and it can result in me, escaping through some loophole. And also personal bias of the judge. Judges are prone to personal bias, yes or no, human beings. Imagine if there's a judge who is constantly fighting with his or her spouse on a daily basis, and the spouse is harassing this judge. Now, when the judge goes to court, finds a case in front of him or her on some mental or marital dispute where one spouse is beating the other spouse, don't think the judge has more sympathy with the spouse of his or her gender? Yes, that's possible. So these things are there. That is why these are issues pertaining to capital punishment. Now, what can be a way forward? Suggestion. That's more important. What is a way forward? See, as a way forward, let me tell you, frankly, the purpose of justice, the purpose of a death sentence or a sentence or a punishment, of course, is to prevent people from committing a crime, but also reform. Now, we have to understand the difference between retributive justice based on vengeance and reformative justice based on reform. So, take steps for reform, which could be through improving the jail conditions, because as of now, the jails are not some reform centers, right? Jails right now are places where people learn new tricks. You go as a noob criminal, you come out as a legend level criminal, learning new tricks of the trade. Okay, so it is very, very important to understand that jail conditions have to be improved. We can also opt for counseling of criminals. But let me also clarify that taking a very strong stand that there should be no death sentence may not go down well with some people. So what we can do is simply write that take steps for reform. If beyond this, somebody is not reforming only for habitual offenders, death sentence can be considered in extreme circumstances. However, if the convict shows no sign of reform, death sentence may be considered. Okay, this can be a generic standard conclusion for such a question where we are not too biased, have too strong opinion against or in favor of something, right? And just to conclude it, the Law Commission (262nd) report had suggested that this should be given only in case of terrorism. Only for terrorism. That's it. So this is with respect to capital punishment. While we were discussing the clemency powers, I thought it would be more appropriate to just move a bit forward and discuss this also, because for quite some time, discussions have been doing rounds on possibility of this question being asked in the UPSC. Okay, that's it. Now, coming to see, for those who are talking, somebody talked about Jeffrey Dahmer or Ted Bundy and all. Ocean. See, Jeffrey Dahmer and Ted Bundy, these are, I mean, more reasons for counseling, because these people are mentally depraved. Are they of sound mind? So, more reasons for counseling. And once you keep somebody in jail, you're already confining the person to a limited area where they cannot commit a crime. Right? That's it. So, that's it. Now, let's move on and look into, let's come back to the precedent. So we were discussing Article 72. We ventured further ahead a bit to discuss some additional topic related to Article 72, which is death sentence. Now let's come back again. Okay. Jyoti, possibility of reform. Reform means what? Improvement. What is this reform? Do you reform yourself? Reformation inside a person. You commit a crime, you improve now. You never studied before that, you improve now. Right? That's called reform. Okay. So there is always a possibility of somebody improving their behavior. Maybe 9th, 10th, you do not study at all, but see now you're preparing for UPSC, which is only studies. Reform. People always reform. Big or small, good or bad, reform always takes place in people. Okay. And if people do not reform, then I have said here, don't we follow all this? If the convict shows no sign of reform, death sentence may be considered. Vanshika, okay? So that's there. And guys, let me just end this discussion now, that these are just points, pros and cons, and a sample way forward. You are free to use what? Your own argument and come up with your own conclusion. I have just given you an alternative. No problem at all with respect to you saying, yes, there should be death sentences. It's okay. That is the whole point of having our own opinion. But I also think that it's my duty to give you a standard way forward. You can deviate from the way forward without creating a hula baloo in the comment section. Okay. Now, coming back to the legislative powers. So, we are now going to discuss legislative powers, starting with this point that the president can summon or prorogue the parliament and dissolve the Lok Sabha. Okay, let me just clarify one thing here. Two things, or rather, not one. Number one, sessions of the parliament. Sessions of parliament. So we know that parliament has two houses, Lok Sabha, Rajya Sabha. These houses meet, and there are three sessions that we have. Budget session. Next, we'll have the monsoon session, and then in the year end, we have winter session. Normally, budget session from January to April, monsoon July, August, and winter November, December. These are the three sessions that we have in the country. Now, these sessions are not mentioned in the Constitution. From this date onwards, in the class, while I am teaching, I will use this symbol for the Constitution. Okay? Please don't use this in your answer writing and examination. It is only meant for the class. Clear on this? And please, after 3 days, don't ask me, what is this C? Please, it just saves time in unnecessary things. I'll be grateful if I have not asked this question. Maybe today only somebody asked after half an hour, waking up from sleep. What is this C happening? What is the symbol? Constitution. Okay. Now, sessions of parliament. There are three sessions, meaning houses, MPs come and sit in the Lok Sabha, Rajya Sabha, meet and discuss. Like on the 19th of June, your polity session started, which will continue till 21st of July. Polity session. Collection of various days of polity classes means one session. Clear? Okay. Now, something called a sitting. Sitting in the parliament. Every day when the parliament assembles, that day is called a sitting. Every day that the parliament meets, we call that sitting of the parliament. Right? Like today, it's a parliament polity sitting. Tomorrow, polity sitting. From 19th of June to 21st of July, polity session, which comprises of various polity sittings. So what happens every day in the house? This is a timeline. Our MPs have to work a lot. They have to work a lot, right? And the house starts at 11 a.m. early in the morning. MPs get up early in the morning. Then from 11 to 12 p.m., we have something called question hour. What is question hour? MPs ask questions. What kind of questions we'll discuss later on. Don't worry. From 12 noon to 1 p.m., we have 0 hour. What is 0 hour? Again, MPs ask questions. What kind of questions we'll discuss later on. From 1 to 2 p.m., because MPs are working for the past 2 hours, they get tired. They want break. Like some of you want break. We'll take a break after finishing this topic. So please hold your horses. Right? From 2 to 6 p.m., we have legislative proposals discussed. Meaning, bills are discussed from 2 to 6 p.m. This is what happens every day when the parliament meets. Sitting. Clear? Sitting every day. Session is collection of sittings. Now, Lok Sabha till 6 p.m. Raj Sabha till 5 p.m. So Raj Sabha officially used to function till 5 p.m. only. But in practice, they also function till 6 p.m. They also say, we are also equally good. Why will we go? So this is there. Now, I hope this point is understood. Let's come to this part. Whenever right now there is no session going on. Okay. So this means we are between budget session and monsoon session. The gap between two sessions, this time between two sessions is what is known as what? The gap between two sessions, this gap. Recess. It's called recess. And please understand one point, that recess, the gap between two sessions can be maximum how many months? 6 months only. So there cannot be a gap of more than 6 months between two sessions. Okay? How can there be a gap between two sittings of 6 months? One sitting today, next sitting after 6 months? Of course not. It's a gap between two sessions. Now, who calls for a session? That is called summoning. Summon means what? A session begins. So the president will call all the MPs. MPs, come on, come to Delhi. Let's start the monsoon session. Session begins. And this is done by whom? Done by the president. After the session is over, last day, speaker ends the sitting, go home. Then the president will officially issue an order. For what? To prorogue. What is prorogue? Session ends. Done by the president only. Called prorogation. Prorogue means to end a session. Summon means to start a session. Start, end, start. I hope this point is clear. And of course, as I said, the maximum gap between two sessions is 6 months. Both these things and this point, it is mentioned under Article 85 of the Indian Constitution. Okay, it is mentioned there. Please don't ask me, is this real power of president? It is not. It is done on the advice of Council of Ministers. Am I clear on this? Nothing is real power till I say so. Okay, Council of Ministers. Now, she can summon or prorogue the parliament and dissolve the Lok Sabha. She can summon or prorogue the parliament anytime, any place. As she thinks fit. Okay. So this is what the president can do. And she can also dissolve the Lok Sabha. What the hell is this word dissolve now? Dissolve. Dissolving the Lok Sabha means, don't think they are dissolving like some piece of paper gets dissolved in water. Not like that. The tenure of Lok Sabha ends, dissolved, which means now time for new elections. MPs are said, go, get lost now. Time is over. Now we'll go for new elections and we'll elect new MPs who can harass the country in new, who can develop the country in new ways. That is called dissolution. Okay. Which means time for general election. Who can do this? This is done by the president. Now you will say, sir, is it the real power of president? Of course it is not. Only real powers when I tell you. Otherwise, Article 74. Always assume Article 74. Article 74 by default, meaning advice of council by default. Clear? So this is, and this is also Article 85 only. This is all Article 85. Clear? Now, just one point. Just like the president summons a session, prorogues a session. Who starts a sitting? The presiding officer. Who ends a sitting? Sitting of a parliament adjournment means ending a sitting. So today at 9:30, I'll tell you guys that's it, guys. We have had a nice class now. Please go and study. We'll meet tomorrow. That's called adjourning the polity sitting today. We will be adjourning the polity sitting today. Okay? And this is done by the presiding officer. Presiding officer. Sometimes the date of next meeting is not fixed. See, if I adjourn the polity sitting today, I am telling you, let's meet tomorrow. Or I adjourn on Friday, I'll tell you, let's meet on Monday. But on the last day of the polity sitting, I will adjourn the sitting, but I don't know when you have to come next. The management will message you that, okay, come on Monday for a new class. I don't know. So I will adjourn the sitting, and when I don't know the date of next meeting, I will call it adjournment sine die. Adjournment sine die or sine die, same thing. Ending sitting when date of next meeting is not fixed. This is also done by presiding officer only. Are you clear? So summon and prorogue done by president, adjournment done by presiding officer. That's it. Basic information that we should have known. Now let's do one thing. Let's take a break, and after break we'll come back and discuss and continue further. Clear? Break, please. come back at 7:50. Okay, let's continue. Kishan, there is no need for any separate list. The notes are sufficient. Who adjourns the sitting? Nirbhay, such a sweet question. Adjournment is done by the presiding officer. Janvi, sir, you had said under Article 85 no real power. But dissolution of Lok Sabha, president discretion. No, not really. There is one small element of discretion there. We'll discuss towards the end. If no party can form majority or form the government, only then. We'll discuss that later on. Yes. Presiding officer can be of Lok Sabha also, Rajya Sabha also. In the Lok Sabha, it's called speaker. In the Rajya Sabha, they call it chairperson. Common name, presiding officer. Ramavat, very good question. We'll discuss that topic only next. Ordinance. Ayush, how does misbehavior not come under the constitution? Because it is not mentioned there. Simple. Randhava, adjournment ends a sitting, proroguing ends the session. If I end the today's class, that's called adjournment. I end the entire polity classes only. That's called prorogation. No, Nirbhay, sessions are not adjourned. Sessions are always prorogued. Pooja, meaning of adjournment means today's sitting is over, adjourned. That's it. Great, Deepak. Amazing. Chetna, I think Chetna, what is case study was answered by the sub-expert. Case study is studying about a case. How they decide which presiding officer will adjourn? Arey Anushka, for the Lok Sabha presiding officer adjourns. For the Rajya Sabha, the Rajya Sabha presiding officer adjourns. Jayanta, difference between local jail and central jail. What is local jail? Jails and jails which are called central jails. Central jails are those jails specifically chosen wherein the center also sends funds. Half the funds are sent by center to maintain those jails. Okay, that's called a central jail. Ananya, what is death sentence basically? Strange. Death sentence basically means killing somebody basically. Okay, that is death sentence. Mukul, again the same problem. Nobody is ignoring your questions. Don't feel too privileged here. Ask your question rather than mentioning these things. That deliberately. How is presiding officer decided? Later on. Focus on this only. Why are we suddenly asking all these questions from presiding officer now? We'll discuss it in the parliament. Don't worry at all. Okay. Some points we know we have read somewhere trying to impress that, oh, I'm asking question from a future topic. Did it make any sense? No sense. Okay. Enough. Haji Mukul, where is your question? What question was it? Why will CM want that Lok Sabha gets dissolved? Mukul, why will the CM council ministers want Lok Sabha to get dissolved? Basically, it can be firstly at any point of time if the PM feels that no, he does not enjoy the majority in the house, there's some problem in the functioning, he feels elections are better, he can ask for it, they can request for it, and it is also done officially after 5 years end. That's also official. Okay, now enough. All the discussion, most questions are for future only. Moving on. In continuation with our legislative powers, next is the right to address. Address means give a speech. Look at the president here. She is addressing the house, delivering a speech in the house, right? That is called address, the right to address. Giving a speech, addressing both the house. Like I am addressing all of you sitting here, that is the right to address. Right to address can be mandatory, can be optional also. This is Article 86. Optional. At some point of time, let's say the president today at 3 a.m. in the morning is watching YouTube shorts and looks at some motivational video on public speaking. says, now I'll give a speech. She'll say, houses, come to Rashtrapati Bhavan. I want to give a speech right now. She can do it. She can address either house, Lok Sabha or Rajya Sabha, or both houses assembled together anytime she wants. But that's optional. When she feels like I want to talk to somebody, I'm feeling very lonely, alone, I want to convey my emotions to people, whatever. No, but this is an optional power. She may do it, she may not do it. Okay. Then we have mandatory. Now there are some occasions where it is mandatory for the president to address both the houses assembled together. Both houses, Lok Sabha and Rajya Sabha, they have to sit together. This is one example of mandatory address. Look at this. This person is a VP, Vice President of India, the presiding officer of Rajya Sabha. This person is the Speaker of Lok Sabha. This is a classic case of a joint sitting of both the houses, which takes place when? On two occasions. Number one, commencement of the first session after each general election. Whenever the new Lok Sabha is elected and the newly elected MPs meet for the first time, the house is collectively addressed by the president. All MPs sit in the Lok Sabha and they address the president addresses both the houses. Second, at the commencement of the first session of each year. What is the first session of every year? Look at this. First session of every year is the budget session. So the first day of the budget session actually begins with what? With the president giving a speech called the president's speech. On these two occasions, it is mandatory for the president to do what? To give a speech. Otherwise, it's optional. These two occasions, mandatory. Clear? Then, next pass. Right to send messages to parliament. What kind of messages? Not some WhatsApp memes, etc. Messages with respect to bills or otherwise, etc. WRT stands for with respect to. Please, normal course of things, we use this word commonly. So don't ask me after 30 minutes. What is WRT? What is happening here? With respect. Apart, this is also mentioned under Article 86 only, that any point of time, the president can send any kind of message to the parliament to ask information. What discussions are going on? I am getting bored. Please inform me. Then, this is Article 80. See, guys, I write all these articles because in case anyone is interested, they can go and read the article. These articles, most of them are not important. Don't worry. Once the chapter present is over, I will tell you which articles are important. So don't panic. Now, the president also nominates 12 members in the Rajya Sabha from amongst persons who have very special knowledge or practical experience in the field of 4 fields: literature, science, art, and social service. Now you will say, who has the power to nominate? The president? Of course not. What is default? Article 74. The government nominates. Binding advice of the Council of Ministers. For example, who is this person? Justice Ranjan Gogoi, former CJI. Who is this lady? This is Dr. Sonal Mansingh. Okay, so this is with respect to a very famous Odissi and Bharatanatyam dancer who is a part of the Rajya Sabha now because she has been nominated. People like P.T. Usha, Ilayaraja, all these people are nominated. Clear? Now you may say, sir, why was Sachin nominated? Sachin is not an expert in literature and science. Art. Cricket is an art form. Simple. So these words have very wide meaning. Don't think art means your art school drawing. That's not the only limitation of art. It's a very wider form. Anil, again a question has been asked. President nomination is real power? No, sir, it is not real power, sir. I will tell you what is real power, sir. Otherwise, please assume Article 74, sir. Always. Okay? Tara, sir, nominated members are involved in impeachment to president, not in election. Oh, wow. Is it observation or question? It is observation, then it is correct. If it's question, very bad. Because we know this already. So, 12 people are nominated by the president from various fields in the Rajya Sabha, which is again nomination done by the government. Okay. Then, Article 103. Article is very important. See, our MPs who are sitting in the Lok Sabha and Rajya Sabha, they are basically, as members, they are also subject to disqualification. They can be disqualified if they are not a citizen, if you are crazy, unsound mind, if you have become bankrupt, etc. But then who decides on disqualification? The president decides. The president decides on disqualifications of MPs. But don't think it is a real power of the president. After obtaining election commission's opinion, and this opinion is binding on the president. So this is not the power of president. This also is done on the advice of ECI, Election Commission of India. Then her prior recommendation or permission is needed to introduce certain types of bills in the parliament. A very good example would be money bills or Article 3. I am writing Article 3 right now. Don't worry, it is not required to be known. In the future, we'll discuss that. Then she can also summon a joint sitting of both houses of the parliament. What is this joint sitting? This joint sitting refers to what? This joint sitting refers to discussion on bills. We'll discuss this under chapter parliament. Whenever there is any problem with respect to a bill, then the president may call for a joint sitting. Clear? Now, so yesterday I had mentioned this point that, all these classification of powers, please hear me out carefully. Just 1 minute, careful hearing, wake up from sleep. Whenever there is any classification done of the powers of the president, legislative power, executive power, judicial power, all these classifications are done in the books for our easy understanding. In the constitution, there is only one type of power which is clearly mentioned, and that is the legislative power of the president. And that is only one power, which is this ordinance. Look at this statement only from the constitution. Legislative powers of president. Sounds very weird, right? President is a part of executive and still has legislative powers. This is ordinance. Ordinance, as you can see, is mentioned under which article? Article 123. This is ordinances. Article 123. Similar power is for the governor also, which is Article 213. Clear on this? Ordinance. Now, what exactly is an ordinance? See, during recess, what is recess? Gap between two sessions. When a parliamentary session is going on, all the MPs are in Delhi enjoying their life, discussing bills, etc. They can pass bills and make laws. But when the session is not there, like right now, recess is going on, recess, right? We want to make a law immediately. We can't wait for the parliament session to convene in the month of July, etc. We want a law right now, immediately. So what do? We have given the government a special kind of power for a temporary period only, to make a law. That's called an ordinance. So ordinance is also like a law only, but the only point is it is a temporary law which is made by executive. Interesting, right? Laws are always made by legislature, but ordinance is a very unique example where a law is made by executive. That is why for temporary period. So when does this happen? Power of president to promulgate ordinances during recess of the parliament. If at any time, except when both houses of parliament are in session, of course. When both houses are in session, then they make laws. But if any house is not in session, she can promulgate ordinances when either house is not in session. Promulgate means to pass, approve. Bills are passed, ordinances are promulgated. Just a way of saying it, promulgating ordinances. So don't say ordinance is passed. Ordinance is always promulgated. Correct use of word. The president is satisfied. What is she satisfied about? That circumstances exist which make it necessary for him to take immediate action. He may promulgate such ordinances as the circumstances appear to him to require. So if the president feels that there's a situation where I have to make an urgent law, then they can make an urgent laws. Fully allowed, no problem whatsoever. Clear? Now, I had said that this power is temporary in nature. What's the meaning of temporary? Okay. Now, this temporary means because laws are always made by the legislature. Right now, because the parliament is not there, okay? So for a temporary period, we are giving the government the power to make laws. Okay, this is a power of government, not of president, right? This is done. Before you ask this, on COM advice. I don't know, I'm now tired of saying this again and again. But every time somebody will ask this question, is it the real power? It is not the real power. I'll tell you it's the real power or not. Don't worry. Okay. Now, right now, I have made an ordinance. I have promulgated an ordinance because House is not in session, of course. In July, let's say 15th of July, right? The House comes into session. Okay, no problem. When the House comes into session, then what happens? I have to put this ordinance in the House in the form of a bill. That listen, Lok Sabha, Rajya Sabha, when you were not there, MPs, we had to make a law immediately. We made a law. Now this was the ordinance we made. Please approve it. Within 6 weeks from the date that the House assembles, we have to table the ordinance in the House as the government, and the House will then approve it. If they approve it, the ordinance becomes a law. If it is cancelled, then the ordinance is not about law. Okay. So this is with respect to the what? This is with respect to ordinances. I hope this point is clear. So ordinances are nothing but temporary laws only, made when the parliament is not in session. I am repeating, ordinances are temporary laws made by the government when the parliament is not in session, right? So this is what is an ordinance, and it is mandatory to put this ordinance in the House when the houses come back, right? And the houses have to pass it within 6 weeks. It shall be laid before both houses of the parliament and shall cease to operate and at the expiry of 6 weeks from the reassembly unless parliament approves it. Meaning, must be tabled or must be passed by the parliament within 6 weeks from date of meeting. Clear? This is about ordinances. Now, just to point this out, you may find this in the books mentioned, though is of no importance to us, but still. Monsoon session, budget session. If an ordinance is promulgated at the end of monsoon session, ordinance is promulgated. This ordinance continues for the entire gap, recess, and continues further for how many weeks? 6 weeks. Yes or no? It has to be passed within 6 weeks. Now, this gap can be how much? Maximum, it can be 6 months. Yes or no? The maximum gap between two sessions can be 6 months. Therefore, we can say that maximum duration of ordinance can be 6 months plus 6 weeks. I hope this point is cleared. Okay, great. So this is all about ordinances. Now some very basic information about ordinances, some facts about ordinances. This concept of ordinance came into being for the first time in 1861. So it was introduced in 1861, of course, by the Britishers. Lord Canning, Charles Canning, introduced the concept of ordinances. Britishers largely misused ordinances because, see, what is an ordinance? When the parliament is not there, the government makes a law. Is it justified for the government to make laws? Of course not. The law should be made by the parliament after wholesome discussion. But we give this power because emergency can happen, pandemic can happen, demonetization, such things require immediate action. We can't wait for 30, 40 days, right? So Britishers largely misused it till 1947. More than 400 ordinances were promulgated. So once we made our constitution, people said in the assembly that don't have ordinance, remove all this ordinance nonsense. Every law should be made by the parliament only. But Nehru and Ambedkar, they both came together and said, wait, don't be so angry. Sometimes we need to make some laws because we understand that ordinance is wrong. Why is it wrong? It is wrong because we are violating the democratic norms. No discussions happening. Some ministers sitting in the closed doors are making laws. It's wrong. It's violating separation of powers. We understand. But despite this, what we want is during times of emergency, right? The point is, it is required because of some emergency, some kind of pandemic where the MPs can't meet only, right? Urgent need for law, etc. So these are situations where we would need the government to make a temporary law. That is why Ambedkar and Nehru called it a necessary evil. It is wrong. Why? Why is it wrong? Because this is a classic example of violation of separation of powers. But despite this, and not just this, also to add this point here, that parliamentary system is being bypassed. Democratic discussions are being avoided, right? We are simply avoiding discussions. So because of this, we are flouting the spirit of parliamentary system, that ideally laws should be made by the entire parliament after detailed discussion, fighting and questioning the government, why this law is required, why this provision, that provision, everything. But here, the ministers sitting behind closed doors are making laws, right? And Nehru told all the people in the assembly that don't worry, we will never misuse this provision. How sweet. Whenever any politician says, don't worry, you should start worrying immediately. Are we clear? And the live example with respect to what? With respect to our country. Till 1962, you'll be surprised. Till 1962, we had 66 ordinances. Not just this, hear me out. Till 2014, we have had 668 ordinances in the country. And till 2021, you'll be surprised, 744 ordinances have been promulgated in the country. 744 times, right? It is so urgent that the government could not wait for the parliament. So urgent. I mean, in the last 4-5 years, for every 10 bills, more than 3 ordinances are brought. And there was 1993 record, 34 ordinances were brought. It seems like the government is running on ordinances only, right? This is what our government loves. Now, let me just clarify for all those people who are in love with facts. You don't have to mug up all these numbers. Just remember, more than 700 times. It's okay. Don't worry. That should be sufficient, right? But see, okay, I mean, these are wrong, but I will tell you an amazing situation that happened in our states. State governments are hilarious in their functioning. You know, states keep on shouting, center is harassing us, center is not following norms. State governments themselves don't follow norms properly. So this is a case in the great land of Bihar, DC Vadwa case 1987. So what was this case all about? This case was all about ordinances in the state of Bihar. So the petitioner DC Vadwa, he was an economics professor who was conducting some research on the land tenures in the state of Bihar. Following his research, he found and also informed the court that between 1967 to 1981 or 1980, in Bihar, I'll be repeating it, 256 ordinances. Between 1967 to 1980 in Bihar, 256 ordinances were promulgated. How many? 256. So, not just this, he also found a very unique kind of concept used. There were situations where 69 ordinances were repromulgated. Repromulgation. Now, what the hell is this word repromulgation? Please follow me. I'll give an example. What is the meaning of repromulgation? How can an ordinance be repromulgated? See, a simple example. We have to understand how and what is a provision for approving these ordinances. Let's say the session is budget session, some gap, monsoon session, gap, winter session, gap, next year again, budget session, again, monsoon session, again, winter session. Now, what was happening was, as soon as budget session is over, ordinance promulgated. You can do it, right? This ordinance continued till here. Now you have to table the ordinance. Don't table it. Don't put it in the house. What happens? The ordinance lapses. It is over. Let it be over. Ordinance lapsed. Done. Okay. Over. Khatam. In the words of Rahul Gandhi. Now what you do, as soon as the monsoon session is over, you bring back same ordinance. Again, as ordinance number 2, same content. Again, this ordinance continues. Winter session comes, you have to place in the house. Don't place it. What happens? Ordinance lapses. Ordinance is over. Khatam. Ordinance lapsed. Let it lapse. Again, when winter session is over, bring the same ordinance. Again, let it continue. Again lapses. Again session over. Again bring the same ordinance. This keeps on happening over and over again. Take no effort to get it passed. Why to get it passed? Let it be. For 15-20 days, that ordinance will be declared cancelled. As soon as house ends, bring it again. Again continue. Right? because every time you are bringing a new ordinance, the point here is this refers to new ordinance but same content. Content is the same. You say this is a new ordinance, but the same content is there. You take no effort. Re-promulgation means what? No effort taken to get the ordinance approved in the legislature. Okay. In some cases, this ordinance in Bihar was re-promulgated for 9 years. 9 years, 14, 15 times in certain cases. Then what's the point of having an ordinance, having an assembly? Don't have the assembly. If you want to run the government with ordinances only, I think we should remove the assembly only. Remove it. What's the point? This is a problem called re-promulgation. Then Supreme Court became very angry, and Supreme Court told that what is this nonsense happening? Supreme Court called re-promulgation as a what? Fraud on the Constitution. Fraud on the Constitution. This is what the Supreme Court said. It's a fraud. It's wrong. Re-promulgation. The idea is that whenever houses are not in session, we have to make a law for a temporary period. As in right now, some law is required. Or during the pandemic, MPs could not meet in the parliament. And we needed some law. How to make the law? Government makes a law. That law the government makes is called ordinance. That's it. There is no hidden meaning here. Don't be confused. Right? That law is what is called an ordinance when the parliament is not in session. Clear? Now, the point was that Supreme Court called it fraud, not unconstitutional. Why? Look at the provision here. Does it at any place mention that you are not allowed to re-promulgate? No. The makers of our constitution, innocent people, did not even realize that in future, our future politicians will find this loophole and keep on misusing it. Right? So this was there. This is what is the issue. But the Supreme Court only scolded the government. It scolded the Bihar government. Very bad. Fraud on constitution. In our country, scolding does not work. Look at yourself only. Getting scolded by parents since childhood. Has it worked ever? Thrashing works. Yes or no? Proper thrashing works. But nowadays, we can't thrash kids. Sensitivity. But look at you and your life. You are thrashed and now you are sitting here preparing for UPSC. Discipline. So our MPs, you scold them. Scolding a politician, really, they are thick-skinned people, nice people. They don't take all these scolding seriously. They say it's okay. And this can be proved by the behavior of the Bihar government immediately. See, in this case only, Justice P.N. Bhagwati had said that the power to make ordinances is to meet an extraordinary situation. And it should not be made to meet the political ends of an individual. This is wrong. Don't misuse it like this. Right? You would think now the Bihar government, after getting scolding from Supreme Court, has improved its behavior. No. Let me just clarify. This judgment of 1987, after 2 years only, in 1989, the same Bihar government passed an ordinance called Bihar Non-Government Sanskrit Schools Taking Over Management and Control Ordinance. So they were around 429 private Sanskrit schools. The government took over the control of all the schools, made them government schools. So all the teachers became government teachers, very happy, government job, right? Suddenly they all became government employees, all getting married, getting dowry, government employee, 1980s, late 1980s, very, very happy. This ordinance was re-promulgated again and again. But just 2 years back, the Supreme Court is scolding you that don't re-promulgate ordinances. But the ordinances were never placed in the assembly, never. They would lapse, assembly session over, bring the same ordinance. Lapse, assembly over, same ordinance. Again and again. Finally, the teachers were employed. They started claiming themselves that we are government teachers. In 1991, when new government came to power, it did not bring the ordinance. Ordinance lapsed. End of story. All the so-called government schools became private school again. All the so-called government teachers became private teachers again. Clear? So this is what happened during the late 1980s. Aarti, Parliament not in session? Parliament not in session means right now, recess, when MPs are not sitting in Delhi, they are working in the constituency. I hope you understand, guys, what is the meaning of Parliament not in session. Session means no winter session going on, no monsoon session going on, no budget session going on. That is called Parliament not in session. Okay? So now you may say, why was the Bihar government doing it? You could have gotten the bill passed. Sometimes governments are in coalition. 2 or 3 parties have come together to form the government. Let's take the example of, Maharashtra. Congress and Shiv Sena had formed the government. Now let's assume that if in Shiv Sena has lot of respect for V.D. Savarkar, of course, because of his contribution towards the statements he wrote, etc., and the letters he wrote, spread of education at the lower level and all, lot of contribution. But Congress hates V.D. Savarkar. Look at the great statement made by the Congress, a very commanding leader of the Congress, Mr. Rahul Gandhi. But these two parties were in coalition in Maharashtra. If Shiv Sena wanted to bring some law to give some respect to V.D. Savarkar, Congress would have opposed it. Yes or no? Opposed it. So I would not bring a law because my coalition partner does not want it. I will make an ordinance. That is why ordinances sometimes are used. Anyway, this happened. Ordinances finally expired. All the government teachers became private teachers. All the government teachers who took dowry in the name of government job, their parents came, come on, return my dowry, you private teacher. Give my dowry back. Anyway, spouse is leaving the husband. No, this may or may not be true. I'm not sure of whether this was happening or not. But yes, all these non-government teachers now went to the High Court, Patna High Court, then to Supreme Court, that we are government teachers. How dare you take this tag away from us? We want salary from government. Government, give us salary. So what happened was, this matter went to the Supreme Court, Patna High Court, Supreme Court, and this matter was of 1990s. Finally, in a very quick time, Supreme Court gave the judgment. In 2017, the judgment came. So quickly, in just around 25 years, the judgment came. A 7-judge bench, 7 judges sitting together, they decided. But frankly, this judgment actually solved a lot of problems, right? This was seen as a very important judgment in the field of ordinances because Supreme Court plugged the loopholes that were there earlier. So number 1, Supreme Court said, ordinance promulgation is subject to judicial review. Meaning, if you promulgate ordinances, we can check it. What is judicial review? Judiciary can review. What is this urgency? What is the need? Ordinances are brought only when it is necessary for him to take immediate action. Supreme Court said, we'll check whether in reality urgent action is required or not. Clear on this? So this was first point. Now, this point was also said in a very old case called R.C. Cooper case of 1970. See, in the D.C. Wadhwa case, Supreme Court had only scolded the government that don't misuse ordinances. That's it. That was the judgment. That don't do all this nonsense in future. Behave yourself like how teachers scold you. That was the verdict of D.C. Wadhwa. Then, in the Krishna Kumar Singh, second point, very, very important. Supreme Court said, whenever the government is passing or promulgating any ordinance, it is mandatory that once the houses come back in the session, in the winter session, monsoon session, whatever session they come back, you have to place the ordinance before the house. It is mandatory. It is not optional. You have to. It is mandatory constitutional obligation on the government to lay the ordinance before the legislature. It is not optional because the need, the validity, the expediency, right? Why was it required? The house must check it. Then the house has to approve it also. Then the house has to also, if required, replace the ordinance with a proper law. So you have to table the ordinance. Now, no more escaping this that we will not table it only. You have to. Number 3, re-promulgation is not allowed. Now, Supreme Court has said it can be done can only be done in exceptional situations when ordinance could not be discussed in the legislature. Why? Because of lack of time. Lack of time. Okay? Meaning, if I have tabled the ordinance in the parliament, but the house could not discuss it properly, time is over, session is over, then maybe repromulgation can be done. Are you clear? Then repromulgation can be done. Now, what has the government done? Very beautiful. Government, what it does is, let us say winter session or the monsoon session starts on 19th of July and continues till 15th of August, okay, or 14th of August. On the 14th of August, in the evening, they'll table the ordinance. That house, when you're not there, we pass this ordinance. Please approve it. Now there's no time for discussion only. Repromulgate. Imagine your school days. When you got very bad marks in your school days, report card came. You had to get your father's signature or show him the report card. When did you show him the report card? Just before he was leaving for office. He was at the front gate. Right? Show him the report card. What can he do now? He's getting late for office. Even if he beats you, maximum 2-3 slaps only. Not more than that. The beauty of timing is important. This is what the governments are doing. They don't table the ordinance immediately when the house comes back. They wait. Towards the end, they will put the ordinance in the house. Because now it is mandatory for the government to put the ordinance in the house. They have to show to the house that when you were not there, we had made an ordinance. Are you clear on this? Krishna Kumar Singh, 2017. Okay. So I believe the second point is now clearly understood. It is very simple. I mean, it is mandatory. Constitutional obligation, meaning obligatory under the Constitution. As per the Constitution, it is mandatory that you have to put every ordinance you promulgate in the House. Show it to the MPs. What more simple language can I use now? Tell me. Is it clear? Okay. So, and lastly, the Supreme Court also said that whenever you are promulgating any kind of ordinance, you have to understand that if the ordinance has been put in the house, shown to the house, the MPs in the Lok Sabha, Rajya Sabha, or the MLAs in the assembly in the states, and the house does not pass it, they reject it, they cancel it, they don't approve it, then every action that you have taken in the name of the ordinance earlier, it has to be undone. Are you clear on this? So this is with respect to the last point. All actions taken under the name of the ordinance should be taken back as far as possible if ordinance is not approved. Are we clear? I'll repeat all the 4 points once again in the simplest possible language. Then please look through the live videos to revise. Ordinances, when you are promulgating as the government, Supreme Court and High Court can check, was there actually an urgent need required to promulgate the ordinance or not? It can be reviewed by the judiciary. Number 2, when any ordinance is promulgated when the house was not meeting, when the house meets again, you have to put the ordinance, show it to the house. Number 3, do not bring the same ordinance again and again. It can be brought only if there is no time left. Now, ordinance could not be discussed properly, then in extreme circumstances, it may be allowed. Number 4, if an ordinance has not been approved by the parliament or the state assemblies, because the right body to approve ordinance is the parliament or the state assembly, because they are the ones who make laws, then every such action taken in the name of the ordinance has to be removed, has to be repealed. I hope these points are clear. Right? So this is what is the Krishna Kumar Singh judgment. Largely the problem has been curtailed, but because government sometimes tries to, misuse the power, it's still being done. Not at the same level, but yes, it is still being done. We cannot say ordinance has been, repromulgation is gone completely, it's not being misused. The government still misuse it. Okay. Now, just to clarify here, What more can we do? What more can be done here? See, as far as suggestions go, suggestions. Number one, we should ask the government table the ordinance as soon as session starts. As soon as the session starts, table the ordinance. That means at the earliest. Don't wait. Don't wait for the session to come to an end. Number two, President should exercise discretion. That is, send back for reconsideration if he or she feels that there is no urgent need. Now you may say, sir, what kind of power is this? Even if he sends back the advice to government and the government says, no, sir, you sign it. No, madam, you sign it. He has to sign it. At least when you send back the advice, media can report it. Let's see. President has sent back the advice. What is happening? The government is misusing the power. Media reporting. People, opinion is formed. And people have an informed opinion that government is misusing the power. And based on the misuse of power, the government, then people can go and vote in the elections. And after having all this opinion, the people can go and vote in the elections on the basis of caste. On the basis of development. That's what people can do. Are you clear? That's it. Now, number three, one more thing. Legislature's sitting can be called at the earliest to approve the ordinance, maybe within 7 to 14 days. Okay, so this is the case. Krishna sir, but shouldn't it be tabled within first 6 weeks? Yes, first 6 weeks. But the entire monsoon session is of only 1 month. The entire monsoon session takes place for around 4 to 5 weeks only. Right? That's it. Same goes for the winter session also. It takes place for only around a month, not even 6 weeks. That is why this is a situation. Anyway, that's it. We are done with our Kaiser. Who passes ordinance in state level and Jammu and Kashmir? In Jammu and Kashmir, right now there is no assembly, so there is no need. The parliament will approve all ordinances in Jammu and Kashmir. Okay? Whenever there is a president's rule, the parliament acts. There is no time limit for reconsideration. There can be a special sitting called, not a session. One sitting can be called, right? If you are saying that it is very, very urgent, MPs can't come today, MPs can come after 10 days. You can call the MPs urgently. Okay? Pooja, that's what I said. Third point of suggestion. What is the suggestion here? That call the sitting of the House earliest to approve the ordinance. If it is very urgent, then we should also try to call the sitting of the House, that they approve the ordinance, right? So undoing the wrong done by the DC Wadhwa judgment only actually. They did not clearly say don't repromulgate. The wrong done by the governments in promulgating ordinances. That is what we are trying to undo through this judgment, not we, Supreme Court, of course. Okay. So now second suggestion. Now somebody says our first suggestion. See, I have already explained the suggestions in detail. You can simply look at the live video. Otherwise, we'll be stuck in these suggestions only, right? Done. Now coming to the last power of the president, which is a veto power. This is the actual power of president. For all those people who are very angry, what is this 5 lakh rupees salary given to the president, Rashtrapati Bhavan given to president, right? But now you will see what is the real power of the president. So please don't be angry anymore. Real power. Firstly, what is veto? Veto means the official power given to somebody to refuse to accept or allow something. Veto means refuse to allow or accept. I refuse to grant permission. That's called veto power. Okay. Anyway, one very important point. Bills are passed by the parliament, Lok Sabha, Raj Sabha. It is sent to the president, who then signs, and the bill becomes an act. Lok Sabha plus Raj Sabha collectively, they will pass the bill in their house separately. Now, what happens in these houses, that is a separate discussion. They will pass this bill, yes or no, on the passage to the president. Bill goes to our president. Now, what can the president do? The president can say, very nice, very good bill. The president signs. Gives assent. Assent means signature, approval. Let me write only. I have become very afraid of word meaning type questions. Gives assent or approval. Then I hope you remember, first day bill becomes act. Clear on this so far? This can happen. This happens in most cases. Sometimes the president can also do what? President can also reject the bill, withhold the assent, or reject the bill. Here what happens? Bill is dead. Now, why would the president reject the bill? On the advice of Council of Ministers. This is what is known as absolute veto, but on Council of Ministers advice. Last power of the government. Now next, our president's power. So bill can be rejected by the president when the government says reject the bill. Maybe the bill was brought by previous government and elections happened. New government comes to power. They say, president, cancel the bill. We hate the bill. Then this can be used to reject the bill. Wait. Don't be upset. Just last point of government's power. Now comes the president's power. This is also possible that the president sends back once for reconsideration, that I have some problem in the bill, you please rectify the bill, I don't like it. Possible. If here the Lok Sabha and Raj Sabha if bill is passed again, then the president must give assent actually. Are you clear? Must give assent. This kind of veto power is called suspensive veto. Why? Because for a temporary period, a small period, the president has suspended the passage of bill, has caused a delay in the passage of bill. Discretion of the president. He can do this on his own, right? This is discretion of the president. Are you clear? Now you may say, what is this discretion? He is after all forced into signing the bill. At least he can send it back once for reconsideration. Discretion. Okay. Finally, one power which is like a crazy power for the president. What is that power? The president may also do what? Take no action on the bill. He is not sending it back. He is not cancelling it. He is not signing it. He is doing nothing. Takes no action. When the bill has been sent to the president, she's saying, okay, I'll sign it. Wait. Let me read it first. After 2 days, MPs say, Madam, bill, hands are paining today, can't sign. After 10 days, bill copy is lost. I'm finding it. After a few days, oh, laptop got formatted. Bill was there only. Cannot find it. After a few days, headache, intense headache right now, migraine problem, can't look at the bill. After a few days, I'm out of country right now. After a few days, not feeling well. Right? After a few days, gone to my native place. You are not saying I won't sign. You're not returning the bill back. You are simply refusing to take any action. Here also, bill ends because the president has taken no action. This is what is called pocket veto. It is like the president has taken the bill, kept in the pocket, roaming here and there, doing everything possible, but not signing the bill. Suspensive veto has been used in 2006 by Dr. Kalam. Pocket veto has been used by, in a very famous case, was used by Zail Singh in 1980s. Gyani Zail Singh was the president of India. When the government brought a very draconian kind of bill called Indian Post Office Act, then Zail Singh did not sign the bill, did not return the bill, nothing was done. Okay. So withholding assent means I am telling you I am not signing. Okay, wait. I will give you a better example from your own life. When you express your emotions to somebody, that nice DP, right? Remember, nice DP. I like you, I love you, all this nonsense you do on WhatsApp. If the person blocks your number, right, rejected, or the person refuses, says no, get lost, rejected, right? That is called absolute veto. Your proposal has been rejected. But when you send a message, I really like you, you have seen blue ticks happening, 2 blue ticks, message is read, but no response has come from that side. Now what do? Just wait, keep on waiting. That is called pocket veto. The other person is not giving any response. Yes, no, nothing, silent. That's called pocket veto. Pocket veto does not mean I am saying no or I am saying yes. I am saying nothing. Be confused. This is what is pocket veto. Are you clear? And let me clarify, 2 vetoes cannot be used together. Okay? This is a real power of the president. It can be done for any kind of bill because there is no time limit for the president to give signature. Nothing is mentioned in the constitution about any kind of time limit for the president. So there is no time limit. This is what is called pocket veto, the real power of the Indian president. Okay? Kanishk, I just gave the example. What is the difference between withholding assent and taking no action? When I withhold the assent, I am telling I am not signing. Did you understand it? I am telling you I am not signing. When you said I love you a lot, somebody says I don't love you. Do you understand this? Get lost. That's called absolute veto. Take no action means the person reads your message and does not respond. So taking no action means I am neither saying yes nor saying no. Did I say I won't sign the bill? No. Did I say I am signing the bill? No. I am just keeping the bill in the pocket. Are you clear on this now? See, these words are not mentioned in the constitution, right? Pocket veto, absolute veto. It is just mentioned that since no time is given for the president to sign the bill, we assume it's pocket veto. Clear? So this is there. This is now the case with ordinary bills. Are we clear now? veto power. Number 2, if a bill is a money bill. What are money bills? Detailed discussion later on. I'm just explaining now what is the use of veto there. Now, in case of money bill, the president cannot return a bill. Are we clear? Such bills can't be returned by the president. No suspensive veto. And third type of bill is a constitutional amendment bill where it is mandatory for the president to give assent. Mandatory for the president to give assent. No option, no alternative, no veto can be used. This was made mandatory via the 24th Amendment Act 1971. So this is what is done by the president when it comes to the constitutional amendment bills. Now you may ask a question, sir, can pocket veto be used in money bill? Maybe actually. There is nothing mentioned in the constitution that forces the president to sign a money bill, right? May be used. But the normal logical thing is that since a money bill is introduced with his prior permission only, why will he refuse to sign? Or why will he use pocket veto? But he can, frankly, right? That's the whole point there. He cannot use suspensive veto. So I cannot comment on what is not mentioned in the constitution. I can only comment on what is mentioned in the constitution. This is the case with veto powers, 3 types of veto powers. Now I hope some of you are not really angry at the veto power of the president, that he has some powers. Now, for all those people who are asking, sir, what is the time frame for these kind of bills? There is nothing mentioned. Then you will say, sir, then can pocket veto be used in case of constitutional amendment bills? Maybe. But if you try to use pocket veto in such bills where your sign is mandatory, tell me something. Are you not violating the constitution? If I am the president, I know it is mandatory for me to give sign on the constitutional amendment bills, but I am trying to delay the sign. Am I not violating the provision of the constitution? And if I am violating the constitutional provision, it can be a ground for my impeachment. So maybe if the president tries to act over smart there, the parliament can impeach the president. Possible. Okay. This is there with respect to the 3 veto powers. Veto powers are not mentioned in the constitution. The constitution simply mentions that some bills can't be returned and the president should sign on all these bills, etc. Okay. No prior recommendation is required, Shruti, in case of constitutional amendment bills. Himanshu, CM's advice is not required in case of pocket veto. Chituri, money bills can be rejected, of course, without doubt. Okay. So, world over, we have 4 different types of veto powers. 3 of them are in India. Absolute veto, suspensive veto, and pocket veto. In fact, in USA also, there is a pocket veto. But USA, maximum 10 days. For 10 days, the US president may not sign the bill. But in India, no time limit on the president to give assent. Okay. So in case of USA, the president has to give the signature within 10 days. That is why we say that a very pathetic PJ in Polity is that the pocket of the US president is smaller than the pocket of Indian president. It's a very poor joke, but what can we say? This is the jokes in polity. Enjoy the jokes of polity. Okay? Meaning that the US president can delay the bill only for 10 days, but Indian president's pocket is indefinite, unlimited, right? Okay. Now in USA, they have something called a qualified veto. In India, we have something called a suspensive veto. Both are similar only in nature. Sending back a bill which can be overridden. So whenever in our country, if the president sends back the bill once for reconsideration, if the Lok Sabha, Rajya Sabha pass the bill again with the same kind of majority, then the president has to sign the bill. So normally in our country, bills are passed by something called a simple majority. What is simple majority? More than 50% of people who have come on that day, if they pass the bill, it's okay. Bill is passed. Clear? Whereas in the case of USA, if the bill is sent to the US Parliament, which is called Congress, they have to pass it with a higher majority. Okay? Higher majority, meaning 2/3 members present and voting. Clear? This is what is a higher majority. I'm mentioning here. Before you ask the question, it is being mentioned. Okay. What is the question, Shivani? Nikhil, can you give example of two vetoes can't be used? How can you give example of something wrong? For example, if the president sends back the bill for reconsideration, the bill is passed again. Now the president uses pocket veto. Not allowed. Once the bill comes back, you have to sign it. Clear? This is it. How to make notes? I am making notes for you, writing every damn thing on the PPT. What more do you want? You copy this if you want. Simple. Or take a printout. These are notes only. Rather, revise, revise 10 times, read Lakshmikant, read current affairs, do that, than making notes in your own handwriting, blue, black, green, ballpoint pen, coloring, highlighting, write more answers later on. As of now, please revise. Gauri, what is this question? Please don't exercise pocket veto and answer about Pepsu bill. I don't know what is this. Mir Shabir, how the president used pocket veto? By not signing the bill. That's how they use pocket veto. Okay? I hope this point is clear now. These are the types of veto powers, though not mentioned in the constitution explicitly. Now, wait. Don't jump. What is explicit? What is explicit? What is happening here? Using big words. Calm down. Explicitly simply means clearly mentioned. Okay? Clearly mentioned or clearly written in the constitution. So these words are not mentioned in the constitution. That is called explicit. Vivek, please. What is special majority? Nothing. Ignore that for now. I am telling you what this means. Higher majority and ordinary majority. Don't jump the gun. We'll discuss what is special majority when we study the chapter parliament. Right now, just understand this only. Don't complicate the matters. All I'm saying is that in USA, if the bill is sent back, more number of legislators have to sign. Only then is the president forced to sign. In India, if we send back the bill, if the same number of MPs sign the bill, the Indian president has to sign it again. Clear? That's it. Simple. Ruchi, have you just woken up from sleep or what? Withholding the assent and not taking action. You please revise the video. I have given this explanation 4 or 5 times now. This can't be done because others also are in the class. Done. Types of veto powers done. We are done officially with the chapter precedent. Any doubts that you have the live videos, watch it 10 times, 100 times for your entire life till you have subscription. Keep on watching it. No problem. Who is stopping you? Okay, that's it. We are done with the powers of the president and we are done with the chapter also. Now, I hope you would have a better understanding of the position of the Indian president with respect to the constitution. Of course. So, why do we need the president? For all those people Discretionary powers of the Indian president. There are some situations where the president takes the matters in his own hands. The real power of the president, not following the advice of the Council of Ministers. Discretionary power of the president. Appointment of Prime Minister when no party has a clear majority in the Lok Sabha. At that point, the president can simply do what? Pinky, if the government is amending the important structure. So, see, guys, I also understand that a lot of you must have studied some things here and there in polity or have taken classes prior to it. There is no point in asking all these kind of questions in between. I am not impressed, frankly. It's not required. Don't impress me. I'm already impressed by all of you. It just deviates from the class. So, amendment. If the government makes any kind of amendment, forget basic structure. Amendment bills, no veto power. That's it. What's the point of asking a question which is not being taught in the class right now? Others feel left out. Right? Have the courtesy of asking questions which are related to the current topic only. Anyway, first point, appointment of the Prime Minister when no party has a clear majority in the Lok Sabha. So at one point of time when no party has clear majority, we call this hung legislature. Okay. So at that point of time, any person can be chosen as a Prime Minister by the President. He has to prove majority, but can be chosen. Now, when no party can form the government, when no party can prove majority or form the government, then the president can remove the ministers and or also dissolve the Lok Sabha only in this case. Number 3, returning advice under Article 74. Number 4, getting information under Article 78. Number 5, suspensive and pocket veto. Number 6, pleasure doctrine, which is pleasure of the president. WRT with respect to ministers, not the officers, ministers. Clear on this? These are the only discretionary powers available to the Indian president. They are pretty decent. So they can prevent the government from becoming dictatorial, because if the government has a majority in the Lok Sabha, they can do anything they want. So the president can use pocket veto and all to keep a check on the parliament and also keep a control over the government. That is why we need the president. So if a question is ever asked, should we remove the post only? Please don't say yes, useless post. It has some parts. Clear? That's it. We are done with the chapter president. These are all the real powers. Real powers. We have to write everything. Speaking is not sufficient. Okay. Now, in case you want to read Lakshmikant, feel free to read chapter 17 now. Okay. Important articles. Article 54, Article 71. Article 60 is for oath. When I read the article, you please recite in your mind what the article is. Article 266 is what? Funds, CFI, PAI. 267 is what? Contingency fund. 61 is what? Impeachment of the president. 74 is what? Advice of the president, the council of ministers. Then 361, immunity. Then 310, the pleasure for the officers. Then Article 72, Article 86, Article 87, mandatory address. 103, then Article 123. Okay. 78 is also there, but we'll be studying 78, 74, 75 separately under the chapter Prime Minister. There also it is important. That's it. We have also seen one schedule, which is Schedule 2. Then important cases. Shatrughan Chauhan case 2014. DC Wadhwa case 1987. Krishna Kumar Singh case 2017. That's it. These are the important articles that you need to know as far as the chapter president is concerned. Okay. Now, R.C. Cooper case 1970, not 60, but not required. It's okay. That is going to be sufficient. If you just remember this much, it will be great. Schedule 7 was in the previous module, so we had mentioned there only under basic concepts, right? These things only. That's it. Don't get emotional. Again, let me just remind you, for all those emotional beings here who say, please give me practice question, I want to solve answers. Wait, just wait. On Friday, this Friday only, we'll discuss firstly separately answer writing, and then from that date onwards, I will give you practice questions to write answer also. Firstly, read these topics. The more important point is to at least build on content. After one day only, I want to write answers and write the best answers possible. Be realistic. If you are in this kind of hurry, difficult. This exam requires patience and perseverance. Develop those skills first. Right? This is what is required. That's it. Okay. Now, tomorrow we'll take up for discussion the chapter Vice President of India, and we'll continue our discussion further on the Prime Minister, Council of Ministers, and the Attorney General. Okay, that's it for today, guys. Jai Hind. I'll take up questions now. And yes, before we end our discussion, again the same old story. Revise the notes. Political theory. Read chapter 3 now. Lakshmikant, chapter 17. Monthly magazine. 1 hour of reading. Beyond that, read the editorials from either the Hindu or the Indian Express. Will you be able to do this? I hope you do. Okay, that's it. Niharika, no, the president is not related to any political party. He is free from party bias, on paper at least. Okay. Anjali, I am thankful that the language is tough, right? Anyway, who gives capital punishment? Kanika, the Supreme Court gives capital punishment. High Court give capital punishment. The Sessions Court can also give capital punishment. Yes, Kumaran, it happens a lot. No, Raghav, it's not automatic. It has to be applied for, but it is given very easily. Kishan, contact mentors for that. Manoj, why Subhash Kashyap is not necessary? Why DD Basu is not necessary? Who said it's not necessary? Read all the books you want. No problem. If you want to clear the exam in the next 2-3 years, limited content. If you want to clear the exam in 2034, no problem. Read everything. Who's stopping you? The point is that it is not required only. We already have Lakshmikant to simplify everything. Why do you want Subhash Kashyap? See, I can also show off and impress you that, we should always read DD Basu, the shorter version of the Constitution, 2 volumes, 5,000 pages each. That's not the point. The point is clearing the examination. Right? If somebody is just trying to impress you saying, I am referring to Subhash Kashyap, it sounds cool, but makes no sense. Limited content. Yes, others can leave. Utkarsh, vote value. Vote value of MLA depends. Utkarsh, look at the formula. Vote value of MLA depends on population of the state. That is fixed for 1971. And why does it change for every state? Because the population in every state is different. That is why it changes. Number of MLAs are different. That's why it changes. But the MP's formula depends on all the MLAs of the entire country. That number is fixed. How can the vote value of MP change? It can never change because all MPs are treated on one common formula only. That formula is fixed. It cannot change. Ananya, you can do all this in one day. Come on, be serious. You have been revising for the past 3-4 days also, right? Nirbhay, pleasure doctrine simply means if any minister, just forget all that. If any minister is not following ethical behavior and he is the best friend of the president or prime minister and the PM is not removing him, then the president can simply remove the minister, that you get lost. That's it. Right? Extreme circumstances only. Yes, Anjali, you can do that. No problem. Kishan, yes, it is allowed. Megha, it is necessary. Am I kidding every day? That book is mandatory. What is the big deal about reading a class 11th NCERT book? Himanshu, no, we'll discuss that later on. Nirbhay, do you understand what I'm telling here? You have to sign it. It is mandatory to give assent. You understand? You can't send it back. You can't use pocket veto. It's mandatory to sign. Tajinder, it depends. It depends on what subclause it is. Subclause A of clause 1 of Article 19 is freedom of speech and expression. It is important. So it all depends on the article. I cannot comment that subclause is not important or they are important. It will vary from article to article. President is not behaving properly, Palak. What is not behaving properly? Sachin, not really, not required. Ankur, Article 76 versus 86 difference? What is 76? Attorney General of India. What is 86? Giving speech. What is the common thing here? You please clarify your question first. Navnita, come on. It's a class 11 book here. It's not Greek and all. It's very easy. Focus. Go slow. See, I am covering that NCERT book which is required to be learned as far as UPSC is concerned. But you should also read on your own. Develop some reading skills, basic information. That's why I read that book. Shruti, it's okay. Reading also is okay. Kishan, vote value of MLA in one state is constant here. What is this? In one state, all the MLAs have same vote value. In different states, it varies. Okay. MP's vote value is constant. Yes, Anjali, of course we can. Anshu, where is your question? Let me see. Utkarsh will discuss this under judiciary. Vikram, no for ministers, yes for officers. Anshu, write your question again. Limitation of IS officer power. We are discussing the president. Limitation of IS officer's power. What are the limitations? He cannot make a law. He cannot put people in jail. The IS officer's task is to implement government schemes, programs, policies, and rules, regulations. That's it. Everything beyond that is limitation only. Nisarg. See, if I don't answer a question, the experts will. Don't panic. It's okay. Can I write way forward? Yes, you can write way forward. No problem. That's also okay. Perks for freeform behavior like open jails, parole. Yes, it can be done. Definitely. Rashi, only just. Kishan, delimitation only changes the boundaries, not the number of seats. Boundary changes. Seats don't. That is why when you ask a question in a certain topic with lack of knowledge of some other topic, it becomes a problem. Because right now I don't know what is delimitation properly. That is why I refrain from answering these questions. No, Ganesh, they can meet in any other session also. But they have to meet in the next session and approve it. That's how it is. As soon as the next session comes. Prabjot, it can be if it is not biased. Nisarga, okay. Elected President Navnita can never hold an office of profit. Shivani, yes, you can listen to it. Sachin, political science is no book only. Political science is a topic. The book is political theory, chapters 1, 2, and 3. Yes, Yamya, you are asking me, is chapter 3 equality? The book is right in front of you. Read chapter 3 of the book. What is so difficult in this? I don't really know. I have no idea as to why. And then the expectation that I will be running an entire district. Vanshika, what is KK Singh? 1917. Krishna Kumar Singh. It's not 1917. It's 2017. Short-term memory loss completely. The topic under the ordinance. Anyway, That's all for me, guys. It is always fun reading your comments and also looking at your doubts. But nevertheless, on a serious note, please revise. I see a lot of you making mistakes every day in the questions that we start with practice answers. So that should not be the case, right? Study, revise properly, multiple times, and then come for the sessions. Don't come unprepared for the sessions, right? Okay. That's it for me, and that's all for today, guys. Jai Hind.